I didn't learn my lesson though, because fast forward to in my early 20s, what did I do? Oh, here it is. Uh, I sold marijuana. Merry Christmas, Happy New Year. We are just coming up on the new year, and this is the Gower Cast, number 2. I'm told that the first one is always going to be the roughest, and so here's the second one, and let's see how we do. I got here, before I forget, I want to show you all a book that I received for Christmas, actually. No, it was my birthday. My 50th birthday, I received this book. It's by John Grisham. It's great. I've started reading it. John Grisham and Jim McCloskey, and the name of the book is Framed, and Astonishing True Stories of Wrongful Convictions. I indicated to you in the past cast that I started the practice in criminal defense work. I did a lot of criminal defense work, tried close to 50 cases to verdict, criminal defense. Had 5 outright convictions. I've had upwards of 40 acquittals. Some of the acquittals were straight acquittals across the board. And boy, that's always a good feeling. I remember when I tried my very first case, I got a hold of my law professor from Cooley Law School. It was Professor Peden. He was a previous public defender, and then he became a professor of law, and he was a great criminal procedure professor. And I called him after I tried my first case, which was an acquittal, actually. It was out of Midland County. Jury was out about an hour and 15 minutes. It was a one-day trial, and it was an outright acquittal across the board, 3 counts. So I called him up, and I said, hey, I just finished trying my first case to verdict. And he said, congratulations, you now have more experience than 75% of the bar. And that's true. So this book, Framed, that I've started reading, has 10 cases, 5 that Grisham wrote about and 5 that Jim McCloskey wrote about. And these are cases where actually innocent people were framed by the police. And throughout this podcast, in the infancy of it, I'm going to talk about some of these cases. I won't talk about all 10 today, or I won't even talk about one today because I just started reading it. But the first story has captivated me and really caught my attention. So John Grisham, Framed, I highly recommend it. Actually, all Grisham books I recommend, but this one is a great book to start. And if you have a heart for fighting for the downtrodden, and you want to read about some real abuses of government resources, which unfortunately sometimes includes the police, this is a book for you to read. So give it a read, and I'm going to come back and talk about some of the victims of the crime being the defendants who were found guilty of crimes they didn't commit. All right, so I'm a lawpreneur, and I framed that word, lawpreneur. I took lawyer and entrepreneur, and I slammed them together, and I've started calling myself that years ago. I'm a business owner. I own the practice Gower Law in Bay City, Michigan. And in addition to owning Gower Law, I own some investment properties. I also own a bar and grill, which is right by my law office. If you ever get a chance and you're in Bay City, stop by 600 East, the Ratskeller. Great food there. We'd love to have you stop in. In fact, I coined the phrase, stop in, we'll feed you. So, but again, taking the word lawpreneur or lawyer and entrepreneur and mashing them together takes a little bit of a deeper dive sometimes. You know, what is the dictionary definition, I guess, if you will, of entrepreneur? Well, entrepreneur, the dictionary definition tells us it's a person who organizes and operates business or businesses taking on greater than normal financial risk. And that's what I I did early on. I started the law practice in my car. My filing cabinet was in the back seat of my car. It was a banker's box, and I had a bunch of files in there that I didn't know where. If I needed to know where to grab my files, I would just reach in the back seat and pull out my file and go into court. When I started out, what I would do is I would try to help as many people as I could. So rather than take one case for, let's say, $5,000, I would take 5 cases for like $1,000 each. And one might ask, why would you do that? Well, I did that because, number one, I was smart enough to realize that the majority of cases, and this includes both criminal and civil cases, the majority of cases, well over 99%, the majority of cases result in some sort of resolution. If it's a criminal case, it results in a plea bargain. If it's a civil case, it results in a settlement of some sort. And how do you know, what a good plea bargain or a good settlement is? Well, if both sides of the agreement walk away not 100% happy, the law basically says you've reached a good settlement or a good plea bargain. And so the majority of cases in the criminal realm result in that. So if I helped 5 people at, let's say, $1,000 each on their cases, and versus helping one person for, say, $5,000, and I did just as good of a job for each of those 5 people as I would for one, knowing that the cases are going to result in some sort of plea agreement, I would now have 5 people out talking about who I am and what I did and how I treated them fairly and I didn't overcharge them. So I had 5 individual happy people who would tell 5 of their friends, hopefully, and then eventually it would just snowball and it would go. Now, I'm far from that model of business. I'm no longer helping as many people. However, we've always remained very fair, approachable. Remember, at Gower Law, we always remain approachable. That was part of my branding and who I was. I always wanted to remain approachable. And so individuals can come to us and know, we're not going to gouge them. We're going to charge the fee that we feel and based on our years of experience and know how much time it's going to take to get through. But it doesn't matter because most of the cases do end up resolving somewhat, short of a trial. And when you try cases to verdict, you have to the work on these things. The preparation is what really is the hours that you're putting into the case. When you're in court, if the court's open 6 hours, you might be, or 8 hours, you might be actually on the record only 4 or 5 hours. So the preparation and putting the hours into building somebody's case, their claim, their criminal defense is where the work is really getting done. So what we like to do is help as many people as we can and not overcharge them and not go crazy on this, thinking we're bigger than we are because we are worth a lot of money. You're going to get a great defense, but we're also going to treat you fairly. And if you need somebody to talk for you and to advocate and to fight for you, we are. In fact, that was another one of my marketing adages that I would use as part of the brand was Gower Law, not afraid to fight. And so we really being not afraid to fight doesn't mean that you're going to get in there and start throwing punches. It just means that you're going to say the things that others might not say, and you're going to say and do everything you can legally and ethically to help your client or help your client get the result they really deserve, whether that be a fantastic plea agreement or whether that be a super high settlement. You have to be willing to say and do the things for your clients that maybe somebody else isn't willing to do. So I'm a first generation lawyer. What do I mean by that? Well, nobody in my family ever went to grad school, or in fact, I think on both sides of the equation, I was the first to go to college and obtain an undergrad, degree and then go to graduate school and become a lawyer. And so I'm a first generation lawyer. But I think back to some of the things that got me started prior to making that decision. And as I was preparing for this cast today, I started to think back to, I've been serving people since I was probably, like 9, 10 years old when I had my first paper out. And the reason why I thought of that was because delivering newspapers and getting out in front of people now, I don't care if you're delivering newspapers, or you're cutting grass or whatever you're doing. When you're providing a service to people, there's a certain connection that the customer and yourself will make. And I carried those connections all the way even into my professional life, because years ago, I was approached by somebody who said, hey, we see you on TV, we see you advertising, and we need to come in and see you and sit down and talk to you about getting a will or getting our estate plan together. And I remembered who they were, and I remembered who they were, and I remembered where their house was. And I said, do you guys still live over on Church Street in Auburn? And they said, no, we sold that house years ago. But I told them, I could remember everything about their house, where I delivered the newspaper, what I was doing. And so all these years later, once I got into the legal profession, these individuals, these people remembered me. And I really, when I say 9 or 10 years old, I was probably that young when I was delivering the paper. And so I'm grateful that they remembered me. But what was my journey on to criminal defense? What did you do? Well, and I don't know how big this, podcast or GowerCast will go, how many eyes or viewers will see it. But the one thing with me that you always get is I will tell you, who I am and where I came from, and what I say is what I mean. And so, I need to share some, stories that perhaps don't cast me in the most positive light. When I was younger, my godmother would tell me, be a leader, not a follower. And that always stuck with me. Well, when I was about 17, 18 years old, I made a really bad follower decision. I was at this gathering, this young group of people, and some of the guys there were taking some things that weren't theirs in this house. And I went back in the house, and on my way out, somebody said, Gower, grab that. So I took something that wasn't mine. And it was serious because I was charged with a felony at a very young age. I was less than 18 years old, and I was charged with a felony. And it was because, I was a follower that day, not a leader. So I went through the system, and I always remembered that, like, wow, I had to go in front of a judge, and I was scared. And it was my first time being a criminal defendant. And you say, what, your first time? Well, actually, I've been a criminal defendant twice, because when I was in my early 20s, I did something else, and I'll share that with you. But anyways, when you're young and you make a bad decision and you create circumstances that your choices drew you to, the law is very forgiving. There is it's still on the books. There is a statute in Michigan. It's called the Holmes Youthful Trainee Act. And if you meet certain qualifications, you have a lawyer that's making the pitch for you why you should qualify for this. With the prosecutor's consent and the judge's consent, if you're between a certain age, the courts will give you an opportunity to clear your record and not leave you with a lasting conviction. I had to go through that, and I went through that at a young age, and I didn't learn my lesson, though, because fast forward to in my early 20s, what did I do? Here it is. I sold marijuana, and marijuana is legal in the state of Michigan now, but you still can't sell it. You can grow your own, and if you keep a certain number of plants at your house, you can have some for recreational use. I don't advocate anybody smoking that stuff, but I wasn't in the business of smoking it. I was in the business of selling it. And so I had a second felony. That's a 4-year felony when you're charged with possessing or manufacturing or delivering marijuana. This was prior to me even having a college education. And I went through the system a second time. And lo and behold, I ended up with no conviction. I took responsibility for what I did. And the prosecutor at the time took a chance on me, even though I had the prior, at age 17, bad choice. They granted me some more grace. And I tell you this story because that was, to me, the more serious one, because any drug offense in Michigan will affect your driver's license. And so luckily for me, that didn't happen. And the court allowed me to walk out of this without any conviction. Years later, when I became an attorney, I got sworn in to the bar. And the judge didn't remember me, but I remembered him. And I asked him if he would swear me in. And so years later, I ran into him. He's now retired. And I thanked him and said, "Do you remember swearing me in?" And he said he did. And I said, "Well, years before that, you gave me a second chance because I was a knucklehead twice. And you swore me in, you granted me that grace, and you swore me in as a lawyer, and I never shared that with you, but I wanted to share it with you." And I don't run from it. I certainly do not run from who I am, but it's made me who I am, because going through the system twice, I realized something. I realized that, people deserve sometimes more than one bite at the apple. Sometimes they deserve two. Or sometimes it's not even about deserve. They need to, because I had two bites at the apple, and because the prosecutors in both cases granted some grace to me, I am who I am today. And I went through that system, and I come from a family that didn't have a lot of means, so I had a court-appointed lawyer, and the lawyer probably handled hundreds and hundreds of cases, thousands of cases probably in his career. And when I became a lawyer, I went back and talked to him as well on the first case, and shared with him, I went through, because I wanted him to know that, look, the system gave me a second chance. I made another mistake, and so then I got, another chance, and I walked out unscathed with no criminal convictions. Now you ask, can you be a lawyer if you have this type of history and this background? Absolutely. You can be a lawyer even if you have a criminal conviction. If you've made a mistake in the past, and you decide that you want to turn your life around, you can become an attorney. You can become a member of the State Bar of Michigan, because the test is whether or not you currently possess the requisite character and fitness to be an attorney. And so by the time I got to that point in 2006, I had changed my life and turned things around. And I even shared, with being the youngest elected official in the year 2000, the things that I started doing to build the Gower brand, because, you learn from your mistakes and you move on. I share these things with you because I think that the law was calling me. It was calling me, and I had to make these mistakes in order to further appreciate when I have a defendant or somebody who's accused of a crime sitting before me. I can share things with them and say, hey, look, I've been through this. I've made some mistakes, and look at where I'm at today and the position that I'm holding. And, there's no judgment here because I also made bad choices. So let's do some damage control and get you out of this mess. The majority of people that are accused of a crime have done something. It doesn't mean they're guilty of what they are being accused of, but they were in the wrong place at the wrong time. They made a bad choice. They did something that they shouldn't have done at that moment. And so perhaps you have an overzealous government who wants to charge, multiple crimes, and the person isn't guilty of all those crimes, but maybe they're guilty of a lesser crime. That's where the criminal defense attorney comes in, and that's where the criminal defense attorney looks at, police reports, recorded statements of witnesses, video evidence. I mean, today there's video evidence everywhere. One of the best things ever, I believe, it protects the police and it protects the defendants or the accused, is the dash cam video and the body cam video that police officers have to wear. In every case that we try, I always ask that the prosecution or the government turn over all video or recorded statements, because that really shapes what was going on at that moment. That really gives you a snapshot of what happened. And so it's very important to obtain those through, it's called a discovery process with the prosecution. And they'll turn it over to you. They're required to turn it over to you by law. And then it's important that you watch it and you listen to it, so that when you go into the next step of the case, which is whether it's a pretrial conference or a settlement conference, on behalf of your client, what people said and what was actually going on. Was there chaos in that moment, or what happened? Because all of us today are walking around with video cameras and recording devices. I mean, here's my phone right here. All of us are walking around with them. And so it doesn't take much time to catch what's happening. Leads me to another question a lot of people ask. Is it legal to record? What about on the telephone? Can I record people? In Michigan, we are what's called a one-party state. And so, yes, as long as you are a party to that conversation, whether it's you and one person or you and three people, you can record that conversation without disclosing that it's being recorded. Now, what you can't do is, I think of a Seinfeld episode where George was worried and paranoid that people were talking about him, so he put a recording device in a briefcase, and he brought it and left it on the table, and he recorded the conversation that was going on while he wasn't in the room. He wasn't part of that conversation. That would be what we call eavesdropping, and that would be illegal. In fact, you could be charged with a felony for that. You don't want to do that, but you can record conversations. In fact, we from time to time will get questions about employment law. Now, we don't do a lot of that, but we will vet out those cases and find an attorney that specializes in employment law, and will make a referral to that attorney. But we get people that ask us, can when they have a meeting with their supervisor, record it? And we say, absolutely, you can disclose it and say, hey, it's for my protection and yours. I want to record this. Or you could just record it in your meeting with human resources or with that person, so that you're documenting it. It's not against the law to record a conversation that you're a party to. And in fact, I encourage it, and I tell people they ought to do it, because the recording is going to, you can't argue with the recording. The recording is sometimes going to win the case or sink the case or protect the person who's being wrongfully accused. So record away. One of the things that people call our office a lot of times for is, they've made a mistake or two mistakes, and they were charged with driving under the influence or operating while intoxicated. In Michigan, we call it both. OWI is operating while intoxicated, and DUI, driving under the influence. DUID, driving under the influence of drugs. Think of it as an umbrella. It's all under the umbrella of drunk driving or drugged driving. And if you do that more than once, if you do it two times within 7 years and you're convicted of that, now convicted could be you're convicted by plea, or you're convicted by a jury, or you're convicted by a judge. If you're convicted two within 7 years, the law considers you a habitual violator, and they revoke your driver's license. If you're convicted of three within a 10-year time frame, you lose your driver's license and you're privileged to drive in the state of Michigan for 5 years. And it's really terrible because for the person who loses the license, it's really terrible because if you get any moving violation within that revocation period, you end up receiving what's called a like suspension or like revocation, and your time starts over. So let's take, for example, you have somebody who has a 3 within a 5-year period of time, and they lose their license for 5 years, and they wait 4 years and 6 months or 4 years and 9 months before they call our office and they want to start trying to get their license back. And they've gone through treatment, they've done everything that they're supposed to do, but they drive up to the party store to get something, I don't know, a pack of cigarettes or something. And they roll a stop sign on their way there, and they get a ticket. That's a moving violation. And they'll probably get charged with driving while license suspended. And so that's a misdemeanor. That's not just a ticket. You can't just pay that at the traffic window. You have to go to court and get arraigned and start the process. Well, if they plead guilty to a moving violation, their revocation, I should say, starts all over. So their 5 years will begin anew. It's really, really a harsh penalty. I don't think it should start over by a like suspension or revocation, but that's for the legislature, and they should fix that. But if you get 2 within 7, 2 drunk driving offenses and convictions within 7 years, you lose it for 1 year. You're not even allowed to get a restricted license for that 1 year. And so there's no driving. When your year comes up, you are entitled by law in the state of Michigan to a hearing, so you can apply to get your license back. Now, it's not as easy as just walking into the Secretary of State and saying, hey, Gower told me my year's up, I can come in and get my license. No, back up. You got to go through a whole process. And so that's where an attorney, a law firm that understands driver's license appeals comes into the equation. And I encourage everybody, whether you hire us or whether you hire someone else, you need to hire somebody. You don't want to go in there on your own. Now, some people, they're the smartest guy in the room. They haven't figured out they need to get into a new room because, if you are the smartest guy in the room, you should get another room. They have done it themselves. And there's an exception to everything in life and in the law especially. There's an exception to the rule. The general rule saying hire somebody, you should have a lawyer. There are some people who have gone on their own and convinced the Department of State to grant them driving privileges without the assistance of an attorney. Okay. The vast majority should hire an attorney, as I'm telling you. And when you hire an attorney to go in there, the attorney is going to start building up your case. I'll tell you how we do it in our office. We sit down, we speak with you for probably about an hour, and we share with you some of our playbook, how it is that we will present your case to the Department of State. And in that, we explain to you that, our fee is this amount, and there's going to be some more cost involved. You've got to go get a 12-panel urine screen that has every drug known to man. They want to test it. They want to test for alcohol. So you're going to have to pay for that. And then you also have to go get what's called a substance use disorder evaluation. And the substance use disorder evaluation is you sitting down with somebody. I always recommend whoever it is that did your treatment, sit with that person and see if they offer that service. Because they're going to know you. They're going to know what you went through if you went through their program. The substance use disorder evaluation, or I'll just call it the substance evaluation, is going to go through and tell us your whole history. And so it's very important that you know your abstinence state. And I use the word abstinence because the law says you have to abstain from alcohol for a minimum of 6 months, but we always say a year. We double it. We say a minimum of a year. The most hearing officers in the state of Michigan are going to want to see at minimum a year. Most of them like to see more than a year. So because, that first year you might be on probation. You might be going to classes because you're court ordered to. We want to know, and they want to know, are you maintaining your abstinence without the assistance of a court order or without somebody holding a hammer over your head saying if you violate this by consuming alcoholic beverages, you're going to go to jail or you're going to be in violation. So we like to see, a year minimum, but the hearing officers would really like to see more than a year. So you come in, we get the evaluation ordered for you. You go do that. That's at a cost. You got to spend money to do that. Some of them charge $300. Some of them charge $500. I'm not sure across the board, but I just know there's a range. It's between $300 and $500 to go get this done. And then remember the drug screen. You got to go get the urine screen. So that's going to be, let's call it another $50. So maybe you're at either $350 to $550, and then you got to pay us, right? Our legal fees. So you're paying us for our knowledge and how we are going to present the case for you, because the ultimate goal is to get the license. That's what we want you to get. In addition, they're going to ask for some testimonial evidence by way of a letter, and they want you to talk to people in your circle, people that see you on a regular basis, people that know who you are now, but who you also were earlier. Maybe people who knew you when you did engage in drinking alcohol or smoking marijuana or doing whatever it is that you were doing that caused you to have this license revocation. You get 3 to 5 letters from people. It's got to be a cross-section of your community. Some of these hearing officers, they want you to get, they want the person that was sitting next to you at the bar on the bar stool. Well, if you don't hang out with that person anymore, or if you don't talk to that person because you've changed your life, it's going to be difficult to get that person. I mean, what are they going to write a letter that says, I haven't seen this person in 18 months? I mean, that's just silly. So we will review your letters with you, and we want to make sure that everybody's on the same page here. The date that you began your abstinence, and again, we're using that word abstinence because that's the word that's in the law. We don't say sobriety date. We say your abstinence date, because abstinence is abstain. You've abstained from alcohol. Sobriety could be like, I'm still sober. I had a sip of wine and I didn't get drunk off it. So I don't want to play semantics here, but sometimes the hearing officers do. So we want to say, we want to use that word abstinence, and by its clear definition, it means abstain. So what date did you stop consuming? What is your abstinence date? And so we want to look at the letters, make sure that everybody's saying the same thing, it seems a little silly that all the letters are basically repeating the exact same thing, but that's what the Department of State wants to see. So I say, let's give them what they want. We want to hear from your aunts, uncles, your parents, your brother, your sister, your best friend from high school, maybe a work colleague, somebody that sees you at work every single day that writes a letter that says, hey, I see, John or Jane Doe daily, and every morning when they come in, I've never suspected in the last 2 years that they've consumed alcohol. They don't smell like it. They don't act like it. In fact, we've talked about their problem, and they've shared with us, the struggle that it is for them, but yet they've changed their life. So the law requires that you go through this hearing and you go with a lawyer, and at the hearing, you testify as to when was the last time you consumed alcohol. Tell me the facts and circumstances that resulted in this. How well do you know the people that wrote letters for you? What was your treatment like? How is your life different now that alcohol's there? And one of the most important questions is, are you committed to a lifelong journey of alcohol, being alcohol-free, meaning you will not consume anymore? If you go in there and say, after this hearing and I get my license back, I probably will celebrate with a beer, you're not getting your license back. They want to hear you say that you are committed, because the law, again, presumes that you are a habitual offender. And the reality is that chances are the people that have 2 within 7 or 3 within 5 years, the statistics, unfortunately, are pretty high that they may get another one, and we don't want that to happen. Now they're not just going to grant you a full license and say, "Here you go get your license." You go, no, they're going to say, "We're going to do this in a 2-step process. We're going to grant you a restricted license." Now, my firm and myself, when we do the hearings, we ask for a full license out of the gate. We want people to have it, but we don't lie to our clients and tell them, "Hey, you have a great chance by hiring us that you're going to get a full license." No, we tell them the exact opposite. The chances are pretty high that you're going to get a restricted license. And so the way we do it at our office is our fee is structured so that you will stay our client next year when you come back. And in a year you come back, because again, remember, you're entitled to a hearing every year. We'll go back in a year. We got to do the process all over again. You'll get a full license without restrictions. What restrictions do they grant, or what restrictions do they do? Well, they're going to grant you restricted driving privileges, probably between certain times of the day or during work times. You will be able to go to and from the hospital if something were to happen. But also, they're going to require that you put a breath ignition interlock on your car. We call it the blow and go. They're gonna make you put a blow and go on your car. And so prior to starting the car, you have to blow into this machine to make sure that you have no alcohol, and then your car will start. And then as you're driving, don't have the radio on loud, because it'll beep. It'll want you as you're driving to also give a breath sample. And these blow and goes really, they're really high tech nowadays. I remember I was telling you about getting things on video or recording things. They actually take a picture of the person who's blowing into the device so that they know it's you. And so the state's on to people who are trying to trick the system. I've had many clients in the past, I'm going on 2 decades, that thought they could outwit or outsmart, almost like it's Survivor, the breath machine. And no, you can't do it. You get caught. I put together a legal stack. I told you I was going to do that, and I have I have some interactive. There's some emails that, not emails. Well, I made them into emails. I had some people that there's some groups on social media that people ask questions, and sometimes I'll answer them. I'll dive in, but sometimes others, the paralawyers out there they'll answer them, or the unlicensed people with opinions on everything will answer the question. But some of the questions are pretty good. And so I had a question that came on to the site that I'm a member of. It's not my site. And the person just said, "I'd like to know how to be released from jury duty. I've been selected for 1 month and I cannot afford to work. I'm assuming I'm going to be reimbursed for lost wages, but if I put work down on the release, is that going to be an acceptable excuse?" All right, well, the government's going to give you like less than $20 a day to come in and sit as a juror. So I can understand that that's definitely going to be a problem. I did answer this question on the group page, and I even shared something from when I picked a jury once. But you have to show up. If you get a jury summons, you fill it out, explain what's going on, but you have to show up. And that's our duty, as citizens, to live in a free society. We have to show up for jury duty. Some of us, myself, will never be chosen to be on a jury. But if I got summoned, I would still have to show up, because there's always that small chance, or the exception to the general rule. Because I'm a criminal defense attorney, and I've shared with you that I'm very biased, they would probably boot me off the panel. But I told this person, I said, you have to show up, but explain that it's going to be a financial hardship to you. And explain that, you're probably not going to be paying attention to the facts of the case, because you're going to be thinking of your finances. I'm getting paid less than $20 a day to be here, and I got to pay my bills. I'd rather be working. I think if you're just honest and you show up and you tell the court that, and you tell the lawyers that, they're going to say this is not the right case for you. when you're in a better financial situation and you can concentrate on all the facts, you'd probably be a great juror, but they would probably excuse you on that. And so just be honest, show up, and explain that it's a financial hardship. And I would, if I had to give it a percentage, 9 out of 10 times you would be excused. Now, what's my story? Well, once I was picking a jury, and there was somebody on the jury panel, and they raised their hand and said, "Do you have, we want to know, do you have any biases or anything?" When you're questioning a jury, they call that the voir dire process. So a voir dire means to speak the truth. So we're asking the jury, "Hey, tell us some stuff about yourself so that we can see if this is the right case for you to serve on." So this individual raises their hands, and they said, "I hate cops. I hate them. Can't stand police officers. I don't care. I don't care who they are. I don't care how many badges they have, how many guns, firearms they carry on their side. I don't like police officers." And then they went on and said, and further, this prosecutor's office over here is corrupt. I don't like them either. I don't like them. Well, it's pretty much all they had to say at that point. They were pretty forthright in saying what their opinion of police were and what their opinion of the prosecutor's office were. Now, I didn't disagree that the prosecutor's office was corrupt. I didn't like this particular prosecutor's office or who was leading it. So I kept my mouth quiet. I kept my mouth shut, I should say. And I didn't dare ask what they thought of criminal defense attorneys or lawyers in general. I stayed quiet. And when the judge delved in and said, "Well, I mean, I understand that you say you don't like police officers and you don't like this prosecutor's office. Could you put all of that out of your mind?" I think the judge knew the answer before he asked. And decide the case? No, I couldn't. A lot of times judges will try to rehabilitate the jurors and ask, if I instruct you that you have to put all that out of your mind, can you do justice and hear this case? Well, the bell's already been rung. The whole panel probably should have been released, especially when this juror was accusing the prosecutor's office of being corrupt. But anyways, that juror was excused. I am not advocating that if you want to get off jury duty, you should get on in the panel and say bad things about the police. And, I've evolved, I should say, because, when I started out and I was really, really aggressive towards police officers, I almost, I'd question everything. Well, I come to learn that, these officers have hard jobs, and I need them to do their job so that I can do my job. I mean, if they're not out there, arresting people, my phone's not ringing. And you got to think about it. I mean, the police are, let's say they're working third shift, they have families at home, and they just spend a whole night, pulling people over and dealing with people that are disrespecting them or treating them, terrible. So I got to imagine that there's some sort of, they get a little hard on that. So, but most of them, they'll shoot you straight, and they will tell you exactly what they do and why they do it. And again, we need them. And I got a traffic ticket not too long ago, and I thank the officer, for bringing it to my attention that I was speeding, and told him to be safe out there. I took care of the ticket. I took responsibility. In fact, he wrote the ticket. And if you're respectful to them when they pull you over, I mean, you don't have to ask why you were pulled over, this and that. Just answer their questions and be respectful. Chances are they're gonna treat you pretty well. And this officer actually exercised some discretion, and he said, "Look, I clocked you at this amount over, but I wrote it for this. So if you just take care of it, it should, I think it was like a 1-point ticket or something." And I thanked him, and saved me from going to court and begging a prosecutor to reduce it down to something. But that officer, they exercised some discretion. And so, thumbs up to him for, doing that and protecting us and stopping me from speeding, because I really didn't have anywhere to go that I was speeding. I wasn't paying attention. In fact, I recall I was listening to a newscast, and I was upset about what was going on. And I even told them, I'm very upset with what they're saying and doing against, at the time, former President Trump. And so I wasn't paying attention. And I think he was a Republican, so I give them a thumbs up for that too. Another question that came on another group that I'm on was a tax question. They said, I have a tax question. If I have unpaid credit card bill and I was sued and the court issued a writ of garnishment, can they take both my federal and state returns, or are they only allowed to take my state refund? I also thought about calling to see if they would take half this year and half next year. I owe it, and I'm not denying it. I just fell on super hard times like everyone else. Well, I just read today that credit card defaults are at the levels that they were in 2008. And for those of us that recall 2008, there was a housing crisis that hit, credit card debt skyrocketed, and we are almost back at that same position that we were. Some people may have to explore bankruptcy. In fact, if this individual was sued and got a writ of garnishment, they could file bankruptcy if their debt was overwhelming and they couldn't afford it. That sometimes is the way to go because it wipes everything out. Our office does bankruptcy, and we've helped people get out from underneath a bunch of debt on lots of times. We've been doing bankruptcy since I opened. We only do Chapter 7 bankruptcies. There's two types of bankruptcies, consumer bankruptcies. The Chapter 7s our office will do. If you don't qualify for a Chapter 7, we work closely with other lawyers. There's two lawyers that come to mind. I can give you their names. In fact, one of them, I might have that attorney come on the Gower Cast with me someday, and we can talk about it. Especially, that's kind of an area that we should probably explore, because with consumer debt rising as high as it is, I have a feeling that bankruptcy filings are going to be up. Now, this question that this individual asked, can they take both? No, they cannot. They can only garnish your state income tax return. If it was a federal tax debt, the feds will take your federal tax return. But they can only take your state tax returns. Now, once your federal tax return hits and you put it into your bank account, they can garnish that bank account too. And so then they're kind of taking your federal return. What they can't do is issue a writ of garnishment to the federal government and say, hey, return their money to us on this. But the state, absolutely, this person was correct by saying they thought that they were going to take the state refund. And again, if it gets to the point once you're sued and there's a garnishment issued and they're taking your wages from your job, or they're taking your state income tax return, you can get out from under that, and our office can assist in that. We can help you with that. Well, I don't even know if I'm going to get to the whole stack today. I wanted to talk to you a little bit about some personal injury stuff, and that'll probably be a future episode. We're going to talk also about how come all cases don't make it to a jury trial. Why do judges sometimes kick cases out? Well, if you're in the civil realm, that's called summary disposition if you're in state court. If you're in the civil realm and you're in federal court, it's called summary judgment. And basically it's a quick way to get to the end of the case where the judge says, hey, there's no dispute here. There's no controversy. I'm going to kick the case out and grant a judgment as a matter of law. So again, in state court, it's called civil summary disposition, and in the federal court, it's called a summary judgment. And I brought a couple cases here where summary judgment was granted. And one of the cases, the Court of Appeals in Michigan said that the trial court judge erred in granting it. And I'll summarize it quickly for you. What it was a slip and fall suit, and the individual fell on somebody's property, and the trial court granted the summary disposition. And the Court of Appeals said, after looking at all the facts, it should have went to the jury, because the question to decide the case was basically whether a reasonable person would have discovered that, and then whether or not the property owner, upon reasonable inspection, would have known or should have known of the ailment there that caused the person to fall and get injuries. And in that case, they sent it back. But what was interesting about it was that the case started in 2019 and it was just decided this year in 2024. So civil cases, they crawl at a snail's pace. So they're not the quickest case, and there's no such thing as get rich quick on a civil case. And there's a reason why the lawyers that will take these personal injury cases, whether it be an auto accident, a slip and fall, an injury due to somebody else's negligence, maybe assault and battery or something, there's a reason why lawyers, plaintiffs' lawyers, which we're plaintiffs' lawyers, will take the case on a contingency because, we fund the litigation. We have to spend the money on the lawsuit. We have to spend the money on accident reconstructionists. We got to spend the money on doctors. We got to spend the money on experts if they come in. A lot of times people don't have that money. They've been injured. They're out of work now. So the lawyers will front that money, and then we'll take the case on what's called a contingency. Most lawyers take a third of the settlement, and that's not too outrageous when you consider, as in this case, they lived with the case for 4 years. So we'll get more into some civil stuff. I know we spent a lot of time on the criminal today, and we talked about the driver's license appeals. So thanks again for tuning in. Try to make this as informative as we can. I don't know where it's going to go. I don't know if it's going to last forever or not, but I'm certainly happy that some of you have taken the time to listen. Again, hire local, because the local lawyers here, we know the local juries, we know the local judges, and we know the local legal landscape. So give us a call, and we'd be happy to help you in anything that we can do. And again, thanks for tuning in, and we'll see you at the next episode.